save that to last. We've just got a few housekeeping items to go before. Won't take very long, and we'll get right to you guys. I would like to. We haven't approved the January 16th minutes officially, so I'd like to approve minutes of our January 16th. Second.
Second.
All in favor?
Aye.
Okay. Opposed? Good, thank you. Is there anyone else here tonight that has anything that's here to talk to the planning board here tonight? Everything should have been adjourned first. The only thing I do want to mention is that for the application of 74 White Street, there's a updated memo that has been done. And it mentions a few things that I just want to the site plan should indicate the relocation mailbox. Proposed lighting fixture should be shown on the plan. The plan should show access points to the accessibility. We need details regarding county health approval for the proposed. And the applicant should also consider further reducing the size of the paved parking area on the western portion of the driveway, which is highlighted in the memo that's in the file. The applicant should properly name the site plan subdivision. The street number should be shown at White Street, and all the commercial signage should be removed. This action is considered type 2 action with regard to so no further action is required under SECRA. So that's been adjourned just before the meeting, April 1st. So
the board will have to, there's a request for it. So
yeah.
The board will take a motion.
Okay. So now that we've got all that,
74.
74.
I'll move that accept the request, mutually accept the request for adjournment to April 1st.
And a second.
Second.
All in favor?
Aye.
Thank you. Perfect. Thank you. So that, if there's no one else here other than our Fowler applicant, let's go to that.
Okay. Just as a matter of housekeeping, I've reviewed the mailing and posting affidavits and mailing information from the client. Everything is copacetic. The board has jurisdiction. Alex, do you hang on to these? Good, excellent.
Hello, John.
Mr. Bennett.
How are you tonight?
So my name is.
We don't need a motion to open up on. Right. Got this at this car wash, right?
What
It's
is that?
Robert Rules
The
of
Robert's
Order.
Rules?
It's a
Did you get
cheat
that
sheet.
At the car wash?
You know they have those racks there, so you know it's got to be accurate if you get it at the car wash. But it's
Must be a
according
car.
to Robert's Rules of Order, and I did check the big
You
book.
did not get that at the car wash. You did?
Yeah.
Affirmative.
You know,
Like,
they have
where's that in D.C.?
No, the car wash out there on. Yeah, but I did check it with the official.
We're Renaissance
We just need
people,
to
broad
call
range.
the meeting to order. So thank you.
Should I proceed, Chairman?
Yes.
Thank you. My name is John Bennett from Bennett and Reed, 212 Windmill Lane. Bailey Larkin is here with me, as is Rich Warren and Mr. and Mrs. Fowler are here as well, who are the principals, or two of the principals. So we did, as Mr. Borkwin state, submit the affidavits of mailing posting to the village today. Thank you for acknowledging them. We're here for a sketch plan application seeking to divide an approximately 27.9 acre parcel located in the R80 zoning district. Now, I'm going to be brief because unlike the Zoning Board of Appeals meeting, the primary purpose for a public hearing during the subdivision process is for public input, but I think it's only fair that I give a little bit of a history, not only for the board's recollection, but also for some of the members of the public. This property is capable of a 12-lot yield. I think Rich has been kind enough to put the maps up for me. So under the zoning code and the standard subdivision, this property in this zone would yield 12 lots. And we did submit a yield plan with the planning board for the purposes of demonstrating that. I don't know that we need to show it to you, but for the heck of it, why don't we? I'm sorry, I'm saying two different things. Yeah, so that's the as of right yield on the property, which is something that's required under the zoning, under the village code, not only the village code of the village of Southampton, but under the state village law for us to provide for you. So we've demonstrated that under the zoning code, with the appropriate types of road and park area, the property, even taking out for the roads in the park area, the property would yield 12 lots. The application, again, is for a 7-lot plan. We started out with a 10-lot subdivision, which did not include any open space, or more properly, agricultural land preservation. There are no open space requirements in the village code. However, we did look at some surrounding subdivisions, and the comprehensive plan, which states that recommends a standard of 20% of the total area of the parcel. So this is the 10 lot. This is what we came in with, and then Nelson Pope had a memo, and we had some conversations before the board. We met with the client, and we looked at not only at the master plan, which hasn't been implemented as it relates to open space requirements, but we looked at that master plan, and then we looked what the village had done in the area. So we came up with the 7-lot plan, which has a 25% open space. When I say open space, agricultural open space. As we stated, yes, go right to it. Okay. Yeah, we did. These were some different iterations. You remember, the first iteration had some flag lots, which again, the zoning code of the village of Southampton specifically allows for flag lots, but nevertheless, we seemed that the board was uncomfortable with them, although we find them to be a good planning tool. But in any event, so then we went and further reduced the number of flag lots, and I think
Shifted the flag lots
at the board's suggestion. And then we have one last iteration before the final one? Yeah.
Had the fire marshal.
So we did meet with the fire marshal. And then we now have a stage development which will allow for the use of roads and taking away any flag lots. This might look like a flag, but it's not, because the village code has a provision that states that there's a minimum street frontage of 40 feet. So this does not meet this is more an excess or at or in excess of 40 feet. So it's not a flag lot. It's actually a conforming lot under the village code. So that's important for everyone to realize. So we did look at the comprehensive plan, then we looked at some of the ways that the village has dealt with providing an agricultural reserve. This is not a cluster map. And we specifically did that because we wanted to demonstrate, even though we have a reduced density map, we have also made these lots conforming lots, which is all well and good. We have wetlands. We've included in this proposed wetlands buffer. We've included that we offer that as a covenant. It's 125-foot buffers have been included. I did handle the subdivision over here, which interestingly enough was one large lot subdivided into a larger lot by Phillips Pond and a smaller lot. There's a house there, a house on both of them now. Interestingly enough, the planning board at that time required only a 30-foot buffer. We're offering a 125-foot buffer. So what we've really tried to do is to make this with our knowledge and our experience and our knowledge not only of the surrounding area, but the way the board has acted in the past on these applications, and our knowledge of the law, and Rich Warren's knowledge of the wetlands requirements. We've really tried to make this as compatible. I was about to say as compatible as possible, but as fully compatible with the town code, a village code, and of course a 5-lot reduction of density. Thus, over 11 acres of parcel, thus over 11 acres, actually, if you take into account the proposed wetland buffer and the agricultural reserve, will be open space, almost 40% of the property, which is, again, I don't think that you've seen anything like this in the village. work as hard as we can to make this as something that's acceptable to the village, but at the same time preserves not only the farming, but preserves the value to our client. The board, I think, I just wanted to run through this a little bit more. Some of the concerns that we heard in the past, the board did have, should we talk about the areas design? The board had a concern about maybe providing some buffer along what I call it's the westerly most part of Fowler Street before it makes that right-hand curve and heads south. So we do have a buffer plan that has been presented by Aries Design. We're not married to this plan, but we thought it's at a minimum, it's a good place to start off. We tried to be generous with it. We tried to do what we heard some of the board members concerned in terms of a visual buffer along Fowler Street. So we did submit that. And again, that is not a submission requirement or a requirement of completeness, but what we're trying to do, quite candidly, even though this is merely its sketch plan, was we're trying to work out some of these concerns that the board would have. We also, hopefully, I know we did send this to not only to the board members, but Mr. Borkman. There was some concerns about this property being held in perpetuity as usable only for agriculture. So this is what I did. I took our standard ag reserve covenant that I've used on many subdivisions of farmland, both in the village and the town. And what we did is it has language that says it runs with the land and is binding on the heirs, successors, and assigns. That's usually where most of them stop. But I looked in the document itself. But what I did was I looked at section 247 of the, not only 247 of the New York State law, but 247 of the town of Southampton code. It has a very interesting thing in 247. It says, if you want to change those restrictions at all, you have to have a majority of +1 of the trustee vote, as well as subject to a mandatory referendum. So what I did, since that doesn't occur in the village law, and excuse me, it doesn't occur in the village law. What I did is I grafted that section from the town law onto the proposed covenant here. So what I'm suggesting is, and that's something, since we're offering it, it's something that you could we're offering it as a condition. The ag reserve document, as proposed, as we now have it proposed, says that you have these agricultural activities that can occur as defined in section 301 of the Ag and Markets Law, which is the sort of the linchpin for what agriculture is in the state. And these are the limitations, and if someone wants to change those limitations, we have to go to the trustees of the village, the mayor and the trustees, and get a majority +1 vote. And it's subject to a mandatory referendum. Why are we doing this? I think that's an almost insurmountable hill there to climb over. And the reason we don't have a problem with it is because we don't have any problem with saying that document essentially should pretty much be immutable. So that's important. That's where we are. Rich, can you think of anything else that you want to add? No?
The public comment.
Yeah, let's just hear we'd like to hear the public comment. And again, that's primarily what we're here for. Thank you.
Great, thanks.
Thank you, Joe.
Any questions for John before we go to public comment? Okay.
My John, that John?
This John.
Yeah, I guess I do have a question for John. He started by presenting the as-of-right yield plan, which
Yes.
wasn't, I guess, was shown to us as an example of what you could have done, but wasn't actually in front of us to consider. But that does have a park based on section 9735B1, which is the standard mandating a park of a certain size based on 100 houses per 5 acres, unless there is a park fee.
Mm-hmm.
So we started off with that presumption that there is a park based on the first iteration of the plan shown to us, and then the actual plan has no park. So that has been under discussion with no real explanation for why there is no park.
let me explain to you. I'm glad you brought it up. In order to establish the yield under the not only the New York State Village Law but the Village Code, one chose a park. So that isn't deemed as an offer of a park. That's subject to the discussion between this board and the trustees, is usually, in my experience, how it's gone. So it's not like I'm taking that off the table. It's a requirement of the yield design. And you can't find a subdivision application in the village or the town or wherever in the East End where the yield plan doesn't include a park, because it's a standard subdivision design. Now, it's been some time, in my experience, since the village has taken a park as opposed to a park in lieu. No, there are some exceptions on the much bigger parcels, but has taken a park in lieu of taking a park fee. But that's one of the things you guys are going to struggle with. I'm not saying I'm not taking anything off the table. That's what that was required to demonstrate what the yield was. It's pretty much been the standard that the park fee was requested, amongst other things, because interestingly enough, there's an Attorney General's opinion that says you can take the park fee and you don't have to use it to acquire parkland. You can use it to maintain existing parks. So typically the municipalities like that because it's another revenue source to maintain existing parks. But that's all under discussion. I think you're probably going to talk about that, and the trustees usually weigh in a little bit on it, and then that's where we'll go from there. But I think
that
these
was prior to
down
the park fee being struck down by a Nassau County court and telling us that our code wasn't up to code when it came to calculating the park fee. So we don't really have an option of a park fee the way I understand it. There's only the option. It's not really an option. It's a mandated park under 9735B1 that you must have a park and use that formula unless you find affirmatively that there's no need for a park for whatever reason. I don't know what that
I can elucidate if you'd like. So as for the park fee, you're correct insofar as this was August of 2023, the Nassau Supreme Court, this was the Village Latch case, did vitiate our park fee 9735 insofar as it mandated a park fee without any sort of findings for the requirement, or for that the park fee would be warranted. Going back to the applicability of the park section, 7730 of the New York State Village Law makes it very abundantly clear that we cannot demand or compel an applicant to give us parkland absent a finding that the population increase caused by the subdivision makes it more likely that a park will be needed or creates the need for recreational area. That's a finding that needs to be made. It needs to be ironclad and watertight. There's a long line of case law that comes from that: Commie versus Planning Board of Yorktown, Business Health versus Johnson. That's in Robert Anderson's Land Use Zoning Law and Practice. The village law, as many village laws, or the village code, I should say, as have many across Suffolk County, have not actually caught up to that standard yet. But in any event, the state law does apply and triumph over the village code. I have discussed this at length with our village attorney, Eileen Powers. So that's the current state of the park law, if you will.
Thanks. So just to be clear, 9735B1 of our village code, 973E, which talks about non-residential parcels like this being converted, that we can ask for open parkland. And then 9739 of the village code, which says preservation of natural environment, is one of the things that the board should consider in granting a subdivision, asking for dedication of perimeter parkland. None of those are valid. Is that what we're being advised?
So as
Those
for
don't
a
apply
park, that
at
is
all.
correct.
Okay, so
If you're
our
talking
code
about a
doesn't
park,
apply.
correct.
The code by which this panel was formed and is supposed to judge a subdivision doesn't apply.
That section of the
And
code, that is
a
correct.
ruling
And
that doesn't apply, or what do you base that on?
by the fact that that would be in direct conflict with all of that case law, with section 730 of the village law. I've discussed this with Eileen Powers. I've discussed this with various counsel within my firm, and that is something that I'm confident with. To get to your second point, though, about perimeter parkland, the board is well within its power to ask for what is commonly referred to as buffers. These are planted or in some cases non-vegetated buffers. And as Mr. Bennett just pointed out there, what was the width you said of the buffer there?
150 feet.
150? So
Oh,
I
I'm sorry,
see.
my pardon. It's 125 buffer. The board should be aware that the structural setback for buildings and structures in the village is 150 feet. So that's why we're adhering to that. But in terms of planted buffer, it's 125, which essentially means if your house is here at the 150, you can have lawn in between the 125 and the 150. But the rest of this has to be either left to, in effect, go back, has to be, or sometimes typically those buffer covenants say that you can either let it go or you can submit something called the conservation management plan. And that's typically what people like to do, because what you have is you have actual vegetation with native species in there.
So it sounds like it's semantics and it's splitting hairs, but there is a definite legal distinction between parkland or open space and buffers.
So when they say perimeter parkland, they don't mean parkland in our code, they just mean
A buffer.
vegetation. They
A
just
buffer.
mean- Okay, so why are we here? I'm not sure.
Because there's a buffer.
No, I'm not sure why the board's here, because any of the code provisions pertaining to the subdivision of land, which would guide our decisions, you're saying don't apply or not valid and have been struck down.
Only if they're in direct conflict with the state statute and the long line of common law.
Okay, great.
You can discuss this with Eileen Powers. If you think that my assessment is incorrect, I encourage that.
I would like some clarification on the matter of the green space, because I think in all the discussions the board has had, the idea of the park was that, and by that we were talking about the corridor of grass that would protect the view of people walking or riding their bikes to see greenery.
Mm-hmm.
And the key was that the park, as I understood it, was in perpetuity. Even though the park, quote unquote, would be private, owned by the owners of the subdivision, it would be forever green. Now, if you say that the code has not caught up with the case law, and we would go through litigation, someone would come to court and say, this beautiful strip of grass that people enjoy seeing surrounding this ag reserve and this large subdivision has to be overturned because somebody wants to put a house all the way to the room. That would be hard to state. That would probably be a difficult case to bring.
Oh, I understand where
And
you're
as
going.
Village, standing here in the planning board, all we want to do is make sure that the village of Southampton gets to enjoy the green look of that beautiful stretch. And so if you're saying that you can't call it a park, and you're saying you can call it a buffer, I haven't seen any law or statutes that show that a buffer can be in perpetuity evergreen.
I find
That-
That's all we need to
I
say.
can-
I
no,
really
Is
want
that-
to understand
can I-
this.
is that-
I find this
Just
Is that-
incredibly difficult, because I will tell you that this buffer will have, not only will it be a buffer shown on a subdivision map, I've said this till, I think someone's, I'm gonna be very direct, someone's whispering in your ear the wrong information.
Well, you
Because-
pointed to
if
the
I may, Amanda,
wetlands or
please,
to the court,
Because
we're talking
this,
about the
let
corridor.
me finish.
Okay.
This buffer is going to be shown on the subdivision map. It, like, notes and things that occur on a subdivision map are as binding as if it's in a covenant, number one. Number two, belt and suspenders, there will be a covenant establishing this buffer in perpetuity. The language will say that this buffer covenant is binding on the heirs, successors, and assigns, number one. Number two, as it relates to this agricultural reserve area, I don't know what more I can do than to say that the document will be binding on the heirs, successors, and assigns. And also, we're going to put this super protection in it, which says that, I've never seen it before in the village, super protection to allay these concerns, that it'll have to be, to change the restrictions, a majority plus one vote of the trustees and subject to a mandatory referendum by the voters of the village of Southampton, which means that I don't think you're going to find in a mandatory referendum the voters coming out and saying, "Oh, you can just ignore this area here." I think the confusion is perhaps the fact that the village, very specific village code, as it relates to creation of park areas and what you can extract, is a little bit in limbo. However, there's a state law that takes over as well. So there's nothing prohibiting the processing of this subdivision, number one. And number two, no one's going to, once you agree, and once you impose these restrictions on these two areas, this buffer and this ag reserve area, no one's going to change it. So what,
I
I'm concerned
appreciate
about
that,
the fear.
but I'm not even talking about those two areas.
What are you talking
Those
about
I'm
then?
satisfied with.
Okay.
We are simply addressing the narrow corridor that
Where?
borders Wickapog
Where?
and ends at Fowler.
Here?
And the
Here?
visual, it's the buffer that we were just looking
Okay.
at, the plan.
So
That
right
plan,
here,
would that plan be in perpetuity
Right,
or will it be
absolutely, the
changeable?
same
That's
thing.
the only thing I'm talking
So
about.
I can just give a,
we can offer the same language in the covenant. We don't have I'm not going to
Because
give
that's
this
the
and
key
take it
here
away.
is that we would like the people of the village of Southampton to
Yes.
have a visual that looks pretty as they go down Wickapog and turn to Fowler.
We
And
heard you.
That's
and
it. That's what we're
we-
talking about.
we
Is that
heard-
strip we're concerned with the green in perpetuity.
We
If it's called
heard
a-
you.
If
We-
it's called a buffer,
We heard you.
that's it.
That's why we came in here with this as a working model for it. And that area with this proposed vegetation, whatever we work out, will also be subject to a covenant that will be run with the land.
So run with the land owned by the owners of the, and maintained by the owners, is that how you see it?
That's
But
exactly how we
evergreen,
do it. Yes,
can never be
exactly.
planted, can
Yes.
never be built upon.
No, you don't
Okay,
have to
because
worry
that's all
about
we're
that.
we're
Well,
really, I mean, I'm
you don't
speaking
have
to
worry about
about myself.
No.
That's been just an issue of what you call this green walk that we're just trying to protect.
It's a buffer area. You can see it on subdivisions all over the town, all over the village. It's a buffer area. It's shown it, and we will show it on the subdivision map as we will with this. Show it on the subdivision map, and we'll put it in a covenant.
But what's the problem with making it parkland, which the code indicates it should be, and that would be there forever, and it would be labeled as a park, rather than something that can be transferred to a private owner? You've set up this ag reserve.
If it transfers to the
Feature.
prior owner, it doesn't wash away the restrictions on it.
so I can clarify just on, and you use the correct word, perpetuity, in our concern about if this will endure this design. So the mechanics of it, just to give a very high level overview, if you have a buffer recorded by either a CNR or a conservation easement, it's a written document. These are all recorded with the county clerk up in Riverhead, and they are indexed against the tax map number of the lot. So if the Fowler family, their heirs and assigns, ever do alienate this lot, it will immediately come up in a title search under the CNRs, and prior owners down the line will see that there is this planted buffer there. In addition, what is very common on Long Island is, as Mr. Bennett says, the subdivision map itself, the physical map, which is filed with the county clerk also in Riverhead, will have the buffer delineated on it.
This
And-
came up because you had presented, John, the Old Town development and the wildflowers, which there was some disagreement with some people thinking it was a wonderful addition to the community, and you expressing the idea that it was a total waste. But
I still feel that way, but it's there.
Yeah, I know you feel that way,
Yeah.
but what is the nature of that wildflower for the edification of those who think that it's a nice thing? I think that is something that is dedicated to the village, or called a park, or some other method of
yeah.
giving back something. When you get a major subdivision, the last major subdivision, it gives back to the community. And you started off by saying the comprehensive plan asks for 20% openness. So what is the problem with giving back something that's called a park or something to the village that remains that way and can't be sold to a private individual who down the road can do or seek to do whatever, which is happening with ag reserves around
So-
the place.
So you're looking for us to put the park.
Yes.
That's part of the discussion. That's fine.
We'll talk about it.
We'll talk about that.
Yeah, we've been talking about it, but it just keeps getting dropped.
No, it doesn't.
This is-
No, it doesn't at all.
Well, no,
one
I
that's a
think we've
buffer.
asked for it. Several of us have asked, can we see the park? Where is the park? Could the park come back? Can we call it a park? Can we, make it a park? The subdivision Catty Cornered and Old Town have something that some people enjoy that's called a park that you can walk through. I'm not saying. you
Just
can
if I
walk
can
through
butt
this
in, Old Town, correct me if I'm wrong, Old Town is a cluster subdivision?
I don't know.
Old Town's not a cluster?
In that wildflower corner,
Yeah,
It is
that's a
private
covenant. That's all private.
that's private
property.
property.
Yeah,
That's
it's all
not a
private.
public park.
Well, that's clear in case law and the village law. We can't compel, even if the board does make a finding for parkland, the board absolutely cannot compel public access or public dedication
No,
of the
I
park.
That's
realize that.
understood.
Yeah, I realize that.
But
We're talking
I'm
about a
just saying
visual.
That one, you
We're
did.
talking about that,
Yeah.
I think, in perpetuities, because we have in mind the village of Southampton, people enjoying it. That's a beautiful area. And that corner
I don't see anybody
Yeah.
fighting with you.
Yeah, I don't
I think
either.
it's just semantics
Yes,
here.
yeah.
So,
It's kind of like a rose by any other name.
Mm.
What will make sure that visual corridor, that's just a small thing, will be green, evergreen?
You can either
That's it.
have it
That's
with a
How do
buffer.
we make it?
You can have it with a buffer, or if you want to talk about that as a park, we can talk about that.
Yeah.
It's we're
Um,
And if it's
totally
a,
open.
if it's a buffer, who pays for the maintenance? If it's a park, who pays for the maintenance? What's the right combination of, to make it work for
In fact,
everyone?
those are details that get worked out later in the subdivision process. So here we're trying to understand that you're acceptable to the layout of the roads and the lots. And
Yes.
we've offered to do something in this area in front of the barns. So we'll
you have
figure that out in the details. There's a lot of details that have to get worked out between now and the time you sign them out.
exactly.
We still have the preliminary and the final approval process.
Exactly. Let's open it up to
Yeah.
public comment.
Thank you. Took the
Please.
words out of my mouth.
Will you
Thank
give the rules for public comment?
All right, so members of the public are invited to
Oh, I'm
comment
sorry,
at this
before-
time.
before
Go
I-
ahead.
I apologize. I'm sorry. Regarding public comment, there are letters of support in the file. I would be remiss not to point that out, and I'm sorry for.
If you could confirm, John, that was Joseph Roberto and Scott Klansky.
Yes.
All right, are these in the Dropbox already, Alex?
I believe they should be.
Oh, we have those two, and we have the Long Island Farm Bureau.
Yes, there's a letter.
Is that
from
one
the
also
Long
in the?
Island Farm Bureau, which if you want, I can.
I asked the clerk to put those in the Dropbox.
Okay, just for the edification of the board, there's two letters. I'm assuming Roberto and Klansky are neighbors,
Yes.
and from the Long Island Farm Bureau, which is a group that advocates for agriculture in Suffolk County. So those are in the file for our review. If we are going to move on to public comment, I will ask everyone who comes up to identify their full name. If you're counsel, you can give your firm address. If you are a private citizen, if you could give your residential address. Mark, do you have any special requests, or
Is it 2 minutes or 3 minutes?
there's no rule? It's
let's
whatever.
limit it to 3 minutes, please. Okay.
Good evening. David McMaster, 176 North Sea Road, Southampton, New York. I'm here tonight representing the Albright family, who own residential property directly adjacent to 550 Wickapog Road. I'm here to express their opposition to the proposed 7-lot subdivision on Phillips Pond. As the board members know, under Section 97.2 of the Southampton Village Code, the Planning Board's approval of subdivisions shall be based on conformance with the master plan, zoning ordinances, and official maps. In our view, the current submission does not satisfy any of these requirements and would adversely impact my client's quality of life and potentially property value. We believe the application lacks meaningful effort to protect our local resources, especially waters, wetlands, viable agricultural lands, open spaces, and viewsheds. 550 Wickapog Road is one of the last remaining large parcels in Southampton Village, and one of the few remaining agricultural uses. Moreover, Phillips Pond is one of the village's most important and sensitive ecological areas. Approval of the subdivision as proposed would result in the loss of significant agricultural lands to residential development, greatly diminishing ties to the community's agrarian heritage, which is contrary to the master plan. The current application presents a serious risk to further degradation of water quality at Phillips Pond. In 2022, Southampton Village applied for a water quality improvement grant from Southampton Town, which was approved in March 2023. The grant application cites the critical ecological importance of maintaining and improving the water quality at Phillips Pond. So additionally, the village master plan also identifies the same thing as a high priority issue. Not only does the current application threaten water quality, but also presents risks to natural, historic, and other environmental resources in and around Phillips Pond. Based on a preliminary review of the New York State Office of Parks, Recreation, and Historic Preservation's Cultural Resources Information System database, as well as the New York State Department of Environmental Conservation Resource Mapper database, there appears to be a variety of historic, cultural, and natural resources in and around the subject property, including Long Island's sole source aquifer, federal, state, and local wetlands and waters, for example, Phillips Pond and the Atlantic Ocean waterfront. There are also endangered and threatened wildlife species, the northern long-eared bat and the piping plover, to name a few. Additionally, there are locally designated and National State Register of Historic Places listed properties, such as the Wickapog Road Historic District. If and when this application moves past the sketch plan phase of review, I would urge this board to order a comprehensive environmental review, including a traffic study, property value impact study, viewshed analysis, and archaeological survey of the premises. Although privately owned, this parcel encompasses precious community resources, and any new development should only be approved after the most careful analysis and deliberation. So, respectfully, on behalf of my client, I would urge the planning board to deny this application in its current form, and also with respect to council, I would request that you look into the issue of parkland as well, as I think that you might find a happy medium of being able to condition the, make it a condition of the approval. Thank you.
Do we have anyone else? Just name and address for the record.
Good evening. Brian Halsey, 451 Wickapog Road. I've been around here all my life, many generations, and I've seen subdivisions come, subdivisions go. This is a good plan. I don't know why you focus on the tiny little things. They're giving up a lot of space, a lot of area, and they're willing to keep it that way forever. I know it's to preserve their family. We've done the same thing. We all have to. We don't want to lose our rights. It's very simple. I mean, they should be praised for what they're trying to do and not doing what they can do. I mean, just the traffic, sure, but the density is nothing here compared to what they could do. So I support this. That's all. Thank you.
Do you have any further comments?
Okay.
Anyone waiting on Zoom?
Nobody on Zoom?
I would ask that you close the matter and,
Close public comment.
close,
Yeah.
Would you like us to close it, or would you like to close with the record open for subsequent written?
Those are all generalized complaints. They're all-
The board can close.
So we need a motion to close public comment, but are we actually closing the public hearing on this?
I would ask you to close the public hearing, which
Yeah.
is the same as closing the public comment,
Okay.
remembering that we still have a preliminary application
I
to make
understand.
and a final application to make, and you'll probably have hearings on those.
I understand. So
I mean, I'll
motion,
probably ask you to waive the final hearing, but you may or may not do that.
yeah, motion to close the public hearing on the sketch plan. Second.
Second.
All in favor? Aye. Opposed?
I'm opposed.
One opposed.
Thank you.
I just want to state why I'm opposed. 'Cause
Okay.
You can.
Sure.
Yeah, we just had testimony that it, might be, first of all, we received a memo on the law that hasn't been discussed. It probably should be discussed in executive session or otherwise. So we haven't had time to digest it or talk about it. And then number two, the idea, there's been some testimony that we might want to take other types of testimony about the impact on property values, neighbors, et cetera. So I think some time to consider that, or in the memo, it indicated that we could ask for a second hearing or continue the hearing or whatever, so.
Understood. Thank you.
Yeah, I assume we still have secret approval lies ahead.
That would be
Correct, that's Kathy's.
Yep. But
That would be the sketch plan.
We typically do secret at the preliminary application stage.
Preliminary application
Okay.
stage, yeah.
Okay, and just for the board's edification,
Yeah.
so I know Mr. London
Yeah.
mentioned it, we have kind of a three-tier system in the village of Southampton. We have preliminary, well, we have sketch plan, which we're at the moment, then we have preliminary, and then we have final. So there will be public hearings at those stages. There will be public comment available at those stages. This does not bind us in any way to any course of action aside from a generalized agreement on the form of the subdivision.
I
We
also have to go
also
to
didn't
the, I
talk
also have
about
to go,
the
if I may,
easement.
Ms. Burns, I also have to go to the
Health
This is
department.
the health department.
Yep.
And this, since it's not the DEC, since this is freshwater wetland, they have no subdivision jurisdiction, but we have some work to do in the health department.
Yep, understood.
Can we just also clarify, because we had asked about the Phillips Pond easement for the village to be able to clean up the pond in the event that it does, and
Trustees.
case law was provided that there's precedent for that.
There's an existing easement that runs to Phillips Pond, runs all the way to Phillips Pond. The meets and bounds description runs through Phillips Pond. It was created at first in 1960 by an interfamily transfer between the Halsey families, and then after that, the actual easement was granted to the village. So there is access to the village. There is access for the village to the pond.
So
So
John,
can Alex, can you confirm that? Because I
I
thought
gave
there
you a
was,
copy of the easement.
I thought there was,
It's in there.
it's in there. It's in the file.
Or
I
is
have a
that-
question.
is
It should be in the Dropbox.
so is that determined that there's access that the village has to the pond in the event they have to clean it up?
So, John, there is that easement. It's a drainage easement. Is
Yes.
that wide enough? If the
It's very
village
broad.
needed to get trucks down there to do whatever they do.
The
to
Halseys
clean
will
up
tell you that there have been village trucks down there. So,
Okay,
yeah.
so all right. Look, I'd like to sort of summarize.
I just, sorry. What there was a draft of an agricultural easement. I don't know that any are in the village now. It's very common in the town. But Richard Warren, my main man, he says lots of stuff to be negotiated. That'll be all done as promptly as possible. I'm convinced that of a lot of information that Ricky Fowler and his brother just want to keep farming forever, and they're heirs and assigns, as you say, and heirs and assigns, and over maybe 4 or 5 generations who wants to keep farming. I understand the need, but the agricultural easement is not being approved now. It's a suggestion that it pertain to that corner. The terms of that, as you have invented some additional ones, I would like to reserve seeing in detail.
We sent it to you.
I
So
know,
we do
I've
have,
read it.
it's the 5-pager,
You
right?
also put 4 or 5 examples of other ones in the file.
Yeah, but the reason, because I wanted you to see
Well,
what the
I
general
read-
baseline is, but this is the one we're
I know, I saw that.
But
But
that's the one we're proposing.
that's to be, but we're not approving that now. There
No,
there
no.
may be other, even additional better things to do.
No, you're not approving that now, but Alan, you went to the best law school in the country. If you can find a way to strengthen that easement to make it stronger, have at it, because I'm welcome it.
It's your suggestion. There may be something different and better to do.
Sure.
So,
Thank you.
I think what I'd like to do is start to give some clear direction. Yeah,
Just
sorry.
prior to that, can Alex just, you started moving toward the microphone, I'd just like to hear what you said with respect to the easement that we now have in our possession, our files, that appears to go straight to Phillips Pond and can be used for cleanup, remedial, testing, whatever's needed. Is that what?
Well, we do have a copy of
Yes,
it in the
yeah.
file,
Did you
but
wanna add something?
the legal language that I have to defer to legal counsel to read that and interpret what that means. But I do believe it is a drainage easement. Whether it can be used for the environmental purposes that we're referring to, that's something that we would have to discuss and determine.
And
I can
that's-
review that.
that's-
That was the 1966 or 67.
Originally 60, then 66.
And I think the board's been very clear that that's always been a part, a critical part of the approval process, that, we want to do the right thing here. We're all good citizens and we want to make sure that you can get to that pond.
Yeah,
to clean up.
I think this is a great find, because what it does is we don't now have to have that argument about what I've said all along, which is you can't require public access.
Yeah.
So but it's there.
Yeah.
So
I think it's time to, this has been moving around. As you pointed out, there have been a lot of iterations of this, and I think it's time to start to kind of reach a consensus and provide some clear direction so we can close out the sketch plan and move the process along. And if you will, I'd just like to summarize. I think there are 5 key points, and after we articulate these 5 key points, I'd like to call for a straw poll among the members to see if we have a majority. If we have a majority, then we'll move towards a resolution draft, which we'll vote on at our next meeting. The 7 lots and roads and the road structure is shown in that last plan. I think is you've really moved a long way, and I think everyone's very happy with that. So that's great. You know, the ag reserve at 25%. That's not including the wetland buffer. That's a wonderful thing. You know, we all love that. Of course, the devil's in the detail there, and we've got to see what the covenant and restrictions, and you know, that's subject to a lot of further review. But that's a great offer. The wetlands buffer is critical. You know, that's another great offer that the applicant has provided. Alex, you had a comment on that, just tweaking that. What was your idea
Are
there?
you talking about the wetlands buffer that would go along the pond?
Correct.
Yeah, the board might want to consider, as you mentioned, what kind of covenants and restrictions would be put in place there. For example, if there's going to be, like John said, revegetation there or wetlands restoration, that's something that might have to go get a wetland special permit. But you know, clarifying that language and what can happen in that area would be important going
Thank you. I
forward.
just couldn't remember that.
I can speak to that.
Yeah. Well, we,
Okay.
you know, we've got lots of time to work on that, and that's part of the ag reserve.
Fair enough. Sorry.
We already mentioned the access to the pond cleanup. I think we've beaten that one to death. And the last one that's a really big one for a lot of members of the board is, and it's been called a lot of different things. I like to call it a conservation easement, and it's that area between the little cottage there and to the east along Wickapog and Fowler Street and to the adjacent property on the west. It's that landscaped area, right? And that's, yeah.
Sorry, I thought we were done.
Yeah, it's all right. Right, so you've got basically from driveway to driveway, and that viewscape, that buffer, that easement, conservation easement, whatever we want to call it, and that providing a great view as you're driving by in perpetuity is I think, critical to building support among the planning board for this application. The one thing I'd like to add to that is, as we were considering this, that driveway to the west there, we'd like to see that closed and have that go all the way to the property line there for safety reasons. As more, because that's,
This one
no, the one on your left, my right, that one.
That's to the west, yes.
Right.
you're
Okay. There's a real safety concern there. That's right at the curve of Wickapog. You know, 18-wheelers coming in and out of there, particularly with more traffic if this thing gets developed and there's further development down Fowler Street. We'd really like to give you we'd like you to consider closing that and landscaping effectively from that eastern driveway. And obviously, we appreciate you've got to get trucks in there, so you know, reworking that to make it feasible for large trucks in there. But we'd like to see that western driveway closed.
You should probably talk to the fire marshal about that too, because the problem is one of the benefits of this is you have great circulation.
Yep.
Not only for, farm machinery coming in and that, but in the case of any sort of casualty.
Understood. Sorry, John, to interrupt. But you know, closing that one and reworking the eastern one to address exactly what you just mentioned, you know, we should work on.
Okay.
So if we have those 5 points, you know, if that's the 5-point summary of
Say it again?
of what we have, yeah, go ahead.
So this is their main access in terms of
I
the service
understand.
work. So we'll take a look to see what we can do to make it look nicer for you. So,
There's a real concern that is right there at that curve of Wickapog, right? And you know that that's a high traffic area, and the traffic is not getting any better. So that safety issue, that traffic concern are two. It's safety and traffic management are the two issues that concern the board.
So you want us to try to address that?
We would appreciate that. So if we have those 5 criteria, And obviously, we've got to work out a lot of details with the easements and the ag reserve, or the conservation even, and the ag reserve to convince us that this, sustains in perpetuity. And I think you addressed a lot of that, John, so I appreciate that. I'd like to call a straw vote of a show of hands among the board. Who would support that structure?
If all the questions were
If-
answered,
if-
if everything, all the covenants, all of this, everything.
Obviously. But
Yeah,
those would be the 5 key pieces to the,
Talk to me about what you mean with the covenants, if I may, because
The aquifer
I'm
preserve.
having a really, this is literally as a real estate practitioner
Yeah.
and as a guy who reads title reports all the time, who drafts deeds, who drafts covenants and restrictions, who drafts all sorts of documents that bind the use on a land. I am having a really, it's almost like I'm being asked to prove a negative. I've given you probably the strongest agricultural reserve document that I've ever drafted, number one. Number two, I have told you, and your counsel, I don't care if your counsel goes off, in an executive session tells you this, although there's probably, I'd waive any problem with this, okay? Even though there's no litigation or anything like that involved. But he's going to tell you that a covenant that says it runs with the land and is binding on the successors and assigns cannot be changed without the consent of the person that covenant runs to.
understood, John.
In
I
this
don't,
case-
I don't think
So
the
what-
board members have had a chance to read what you've drafted carefully. I don't know yet, and they have certainly not had a chance to read it carefully or review it, and we certainly haven't had the benefit of our counsel weighing in on that with advice.
Well, I can.
Yeah, please.
So I do have, I did give this a read over. This is the most recent iteration of the agricultural easement. And going towards the perpetuity or the long enduring nature of it, paragraph, it's not a labeled paragraph, but page 4. Would you mind if I just read the entirety of the paragraph? No restrictions on the uses contained in paragraphs 1A, 1B, and 1C hereunder shall be changed except upon the adoption of the local law by a majority plus one of the Board of Trustees authorizing said modifications of said rights and interests, subject to a mandatory referendum by the electors of the Village of Southampton. So that's kind of a two-pronged process. First, the Board of Trustees would have to pass a local law with some attempt to extinguish an ag easement, and only after that, it would then go to a mandatory referendum. So that's a belt and suspenders.
I understand the perpetuity aspect of it, but we're also addressing alternative use to that.
The uses are contained, the limitations of the uses are contained in the covenant.
But the ability to, as we've seen all over with agri-reserves, to come back and say, can I build a greenhouse to store my whatever I'm growing there? Can I build housing for the workers who are working on the farm? Can I expand the footprint of the 5 buildings that are there because there are 5 existing structures
I can respond.
there? And all of that, none of that, I haven't had a chance to thoroughly
John,
read
just
through
John.
this, but
Oh, I'm
none
sorry.
of that
I'm sorry.
seems to be contained in here. So you can have this ag reserve going forward, but it still allows somebody to come back and anything that's attendant to the farming activities that are described, they can try to modify that, which is going on all over the place.
That's not
So that's one thing. I just also wanted to address that I think some of us would like to see a parkland, again, that's asked for in the code 9739 and in 9735B1, a mandatory park. We'd like to see that go around the entire corner based on that formula of 100 houses, and this is 8 houses to the acreage. So we'd like to see it going around, and the code specifically talks about a parkland perimeter. So that's a more protective entity than you're proposing. But it's very, very little. So half an acre is very, very little compared to what appears in other subdivisions. So I think just the one strip doesn't really, some of us feel
Yeah,
it
I
should be
understand.
going around
The one
because,
strip
people
doesn't
bike
work.
down
Yep.
there, they walk down there.
Yep.
Part of our goal is to preserve the character of the area. And you can end up having looming buildings close up to the edge of the road, which is happening all over. So there's all kinds of
Just, I'll repeat for the edification of the board. So, and this is a very high level analysis here. Agricultural easements take many forms. There are many different kinds of documents out there. Some run to private entities like the CPF, some run with the land and are binding on the heirs and assigns whoever purchases the land down the way. But I need to stress that these documents can be tailored to the specific project, can be tailored to the subdivision. A lot can be done within the document. If the concern is looming buildings, there can be negotiated a no further building policy, a no buildings aside from those for agricultural use policy. There are many forms which this can take. Again, that's a very high level
And
explanation.
Tonight is not the forum to start negotiating the covenants and restrictions. Okay, I do not. None of us want to go there.
Thank you.
But I just want to, as a placeholder, say that that's all part of the things that we've got to
Okay.
work on the next step. So
I've been trying to give you comfort on that. It just seems to a certain degree falling on deaf ears in terms of.
no, John, that's not fair.
Okay.
It's- we're
No, no, no,
listening.
no,
It's
in
just
terms
I-
of
you know,
perpetuity.
I just want to be really.
No one's going to escape this
I
stuff.
just want to be really clear, you know, it's like no surprises, okay? So if we have these 5 points that I articulated a second ago,
Already took a vote.
right? A straw poll here of who would support that, show of hands, please. Okay,
Thank you.
and who would have?
Assuming that all questions are answered
just-
as
just-
successfully as I'm sure they will be. If everything goes as we expect, then I think that, I just want to say, because these things have not been drafted, so of course we have to see them.
Yeah,
The covenants have not been drafted.
The covenants are one thing.
Specifics-
The ag easement, you can
Well, I've
have
not
this
seen
if
it,
you'd
so
like.
I'm saying, assuming it's all right, then it's.
This
all
is in
right.
the Dropbox, correct? Okay, so there
All
is a
specific?
yeah, John, before you.
there's a 5-page draft ag easement that we can all discuss.
Yeah, and there, and one opposed.
Yeah, I haven't had a chance to read the covenants and easements,
Nor have I,
and as
so
I
that's
say,
all I'm
I would like it to be called a parkland and labeled as such and go around the corner and
Understood.
be a certain size. So it's very hard in a vacuum to say, you know, I'd like to just see it on a map.
So we'll put
Like,
you
I don't
down.
think it's in front of us.
Yeah.
We just ask for certain things that need to be actually in front of us to be able to
Yeah.
answer that.
Proof.
So
Understood.
I don't know what the straw poll
Yeah,
is. but
well, the straw poll.
I'd love to
The straw-
support it
the
and vote in
purpose-
favor of it. I just like to see those key protections and some guarantee in the language, and I don't really at this point understand who's negotiating the covenants and easements that are perfect according to John, but you know.
Which John?
Understood,
Yeah.
Laura. The purpose of the straw poll is to really, the mayor has asked us to do this before we go down the path of drafting resolutions. It's an efficiency tool, really.
Makes sense.
So for voting for, or showing support for, and one maybe abstain, I need more
You
information.
need more information.
Okay. I need a motion for you to start drafting those resolutions.
Correct, and we
So
can
a
draft
motion
that.
to-
Pending.
I'll move that council draft an appropriate resolution in
Thank
light
you.
of this discussion.
Thank you. Second, in favor, please? Aye.
Aye.
Opposed? Okay, thank you.
And John, you have enough information from the meeting tonight for to draft a resolution? for the
Correct.
next
Yes,
meeting?
I will
Okay.
get this out toot sweet. I will have everyone review.
And then
And
we'll-
just to remind this board, the point of a sketch plan is to reach a generalized understanding and a generalized agreement of the overall subdivision concept.
Understood. Is there any other business before the planning board tonight?
We have a couple of applications that have pending requests for adjournment that the board may want to address. If you'd like, I can go through them.
Please.
So just as a housekeeping note, the public hearing for 656 County Road 39 at Buzz Chew, application 2199, that's been adjourned to the April 1st meeting for its public hearing. Under subdivision review, we have a request from John on Wool Hill LLC, 783 Hill Street, to adjourn that to the April 1st meeting. And also on the lot line amendment for Connemara Corp. at 52 First Neck Lane. And 51st Neck Lane is also an adjournment request for April 1st.
Okay.
So John, unless you have anything to add, for either of those, we just ask the board to approve the requests for adjournment.
So,
unless there's any concern.
Motion to approve those requests for adjournment. Second,
I'll second the Germans.
thank you. All in favor?
Aye.
Aye.
And then the last one on the agenda, Brian Kelly has already been adjourned to April 1st. 74 White Street was adjourned earlier in this meeting.
Sportman, thank you.
865 Merrick Holdings, LLC. Kathy, I don't know if you wanted to discuss secret determination, or we'll put that over to the next meeting.
So for 22 Windmill Lane, I'll be circulating the EAF Part 2 and Part 3 for your review.
There's papers in the file. It's just started.
The Part 1 EAF was submitted by the applicant.
Yeah.
Did I already circulate? I may have circulated draft Part 2 already, but if not, I will circulate that for your review so we can consider I'm recommending a neg deck on that for next month.
Yeah, these are Part 2. Part 2 is a copy of Part 2.
Look at that.
For Merrick,
That's it. Yes.
22 Windmill.
Okay, so if anybody hasn't received that, I'll send it again just to make sure.
Yeah.
Okay. Thank you, Alan.
Sure. So unless the board has any questions about that,
I
we
read it.
can
It doesn't have any issues. It's absolutely clean.
so we can adjourn that for the next meeting if the board would like.
Yeah, motion, so you want a motion, right,
Mhm,
Alex? A motion
yes.
to adjourn 20. It was
22 Windmill Lane.
22 Windmill to the next meeting. In favor?
Aye.
Okay, opposed? Thank you.
So I think that takes care of all of the applications on the board's agenda. You approved the minutes for January 16th. And just a note, at the end of the agenda, the next meeting is scheduled for April 1st. And beyond that, we have a meeting scheduled for April 15th, assuming that still works for the board.
Perfect. I
Do,
think that's,
what will be, what's on the agenda for the first?
So right now, it'll be everything that's been on today's agenda that was adjourned, plus the public hearing for the Buzz Chew application, the site plan.
Okay, thank you.
And then probably a draft decision on a sketch
Wickapog.
subdivision on Wickapog for the board's consideration that John will circulate in advance of that meeting.
Great. And as always, I am available for any questions the board may have. And if anyone wants other opinions, Eileen Powers is always standing by.
Can you find out if there are any, this is a standard form, they've been going on forever in the town, village agricultural easements that have in effect?
I could look into that. I'm not aware of them, but I can look into that.
I don't think there are any, but they might have been. I knew 3 farms on Halsey Neck Lane when I moved here, but the easements, agricultural easements in the village, our jurisdiction is different than the town.
Of course.
Number 2, Alex, could you get us, I am concerned that there are 3 material parcels of land that are serving as farms for the distant memory of the family. They intend to do it forever. The other one is across the road. It is partly developed, and there's some type of easement. I don't know what the legal arrangements are, but we probably have to give notice to the town of this process pretty soon. And there's a 3rd parcel managed by a client of the family on David White's Lane, up behind the Omni. It's not a continuous piece of land to the road. There's an easement through it for the Lynch family. And there's a material piece of land up there, and they're farming all 3, basically as one. And currently, great use of them are for trees. And the applicant, Ricky, is intent on making a real success of the tree business that he purchased as part of the purchase from the Lynch family a few years ago. And he's absolutely, he'll do a good job. He's gonna die in the ditch. He just wants to do it. But it's trees. They don't want lawns. But I'd like to, if they have to provide it, I think you can just get it off the maps. But it's 2 town pieces that are pretty material, even compared to this piece. And I think we should have information about those.
And what information are you looking for?
I'd like to know where the 2 pieces are, and any data as to when, if and when they're going to apply with respect to those 2 other parcels because the family estate is disorganized because Rick Fowler Sr. died too early. It's not the ideal unit. Mr. Warren's been working with him for 15 years on the process. Some of it's owned initially by the widow. Some of it's owned by the widow and trust for the sons. They claim they're working on everything to deal with estate planning. It's really important to help them. We want to make everything we can to help them.
Yeah, I want to reiterate or highlight this, because I agree with Amanda and I agree with Willa. It's not just on the covenants and restrictions for these reserves, which, the easement, or the
Conservation
the
easement
conservation
is
easement or the ag
common
reserve.
nomenclature.
It's not just the perpetuity that's an issue, although I think, we hit that one hard tonight. It's also the use, right? And the depth, we're all gonna be very focused on the details there, so we wanna get as smart as we can on the comps, what's been done in the village before, and we wanna be really clear on, what they can use this for, what they can't, and how ironclad
It's also
that
an
is.
expansion of the buildings at all, because otherwise you're gonna have 5 more
Exactly.
buildings that can be expanded to whatever, and then you don't have any reserve whatsoever.
Exactly.
What I
And
will
for-
do
hang
is-
on, and for the record, that's gonna be a very serious focus, I think, of all of us, as to exactly what that says and how it's worded.
The terms are important, and you mentioned the Community Preservation Fund in your speech a little while ago. For my
Just by way of example.
from my direct information and talking to them about another matter recently, they are fully informed as to this matter. They are fully informed as to the other 2 parcels, of the outcome. And almost all their information has come from Nelson Pope and Voorhees with the details of what's going on here, they claimed.
Okay. I can't really weigh in
I
on,
just-
the records of private
No,
entities,
but the CPF reports to the town, not to the village. Nothing comes to the village except by their municipal agreement. If they do something, want to help an outcome here, do something constructive, it has to go through the town to come to the village. So we are stuck with knowledge of what's going on with this larger puzzle. This is just a piece of the puzzle for them. A huge cost for this little tail that's wagging the dog as to what they're doing in the town.
Can
what I
just
will
say,
do- yeah, go ahead.
I'm a little bit troubled by this meeting in the sense that I'm saying, I'm fine with things so long as all of these ducks are in a row.
Mm-hmm.
And then I'm saying, but I haven't seen no language with respect to, oh, I've drafted that, oh, I've drafted, I haven't seen, I'm a former real estate lawyer. I'd like to see the covenants. I need
Absolutely.
to see them. I need to feel the teeth that are gonna protect the village.
Mm-hmm.
And for me to say that and everybody jumps on, I need to see things.
No,
And
that's
would be-
a
and
very
so-
founded.
So a straw vote on if all these things line up, it's a good thing. It is a good thing, but we need to see them. So let's all try and be on the same page. And if we're not, give each other the breathing room to take that pause and say, I don't believe I've seen that language. I don't believe I feel like I'm
Yeah,
being sort
that's
of
right.
pushed into this. Well, he has, and he believes this, but even the case law is a result of litigation, and we are following a code that has not been, that hasn't gone to
That hasn't
litigation.
caught up.
So,
Well, that-
so if we're told that we should, do X, and you're saying, well, X in the case law, someone's got to bring that lawsuit.
Mm-hmm.
And as I said, if we're on the right side of the village and the people and beauty and everything else, someone's going to be hard pressed to win that lawsuit. I'm just saying. So I felt a little uncomfortable with the way this is going. in terms
Understood,
of-
understood. And I appreciate the feedback. What I will say, and this is also for the board as a whole, the ag easement draft is or should be on the Dropbox.
And
I
it
have
was-
a copy
it-
if anybody
And
was
who
wanting
Yes.
dropped?
to
Is
take
that
it.
with
This is
the
John
law
Bennett,
firm?
yes.
And it
Okay.
should have been distributed to all the board members as well,
got
so you should have it in your packets, and
So
if you don't, let us
I
know.
would ask you all in the
It's a
next
town easement.
couple days if you could do a read through. Give me, you can email me, you can call me, however you'd like to contact me. Give me your thoughts on it.
Has everyone read that? Because I
Yeah.
haven't,
No,
and I didn't know it was there.
I just saw it for the first time.
It was
So
on-
not
But
everyone's
I
read it,
think
and John
I'm-
thinks
it
we
was on the
have, and
board.
you're defending him, and we're saying we don't know.
No, I'm not
It's been in the
defending.
file.
No,
I-
but I mean, you're,
That's why I wanted to make it clear, because from his perspective, it's been in the file for a while. It didn't just appear in the file, it's been there.
well, there has
So-
to be a negotiation there between people,
So
checks and
it's-
balance to make that
yeah,
work.
it's up to
Who's
us
doing
to-
that? Is that John? Are you going to be presenting the changes to that, or whatever needs to be done?
Absolutely. I will review
With
this
input from.
from you all. So
And-
that's why I say as a homework assignment, not to make a joke, if you guys could all take a good read over the ag easement. It's only 5 pages. It's pretty much kind of generally readable, and give me your impressions on it.
Yeah,
And there
This,
are,
I just would like to know this beforehand. I
Yeah.
There-
really
there
didn't
are
see
in the
it, so I
file-
didn't know. That's what I was saying. I haven't seen it. It's like,
Well, if it gives you
you
any,
have
any
it. But
if
I
it gives you
don't-
any degree of comfort, at the stage that we are at the sketch plan, we're just trying to reach a very general concept. So once we go towards preliminary, and obviously once we go towards final, that's where we start to kind of sharpen our edges, and then really get those I's dotted and T's crossed.
But the
Right.
general
And to
consensus-
be clear, that no covenant language is approved tonight. The covenants and restrictions are going to be drafted based on this board's decision. And whatever the conditions that are imposed by this board's decision, those are the ones that are going to be reflected in the covenants. So what the applicant proposed is an example to try and give the board some comfort, but that actual language is going to reflect this board's decision, correct?
there are 4 or 5 letters, drafts, copies in the file of town, not village, town agricultural easements going back decades. First one I
I'm
read was,
familiar with that, but I'm
Almaden-
just saying in this particular case,
Yes.
I didn't see what's in the file
Yeah,
tonight, and
but
then I'm asking.
he sent the latest copy of a write-up of those a couple of days ago to come to us, and Alex distributed it to us, so I did read it when I
So
got
I
it.
didn't get that, but, or I didn't see that,
Yeah.
but
I only saw, I mean, it wasn't a pile, I will be honest, but I didn't get to read it till this morning. But again, I urge everybody, I actually ask you, entreat you, to give this a good read over and let me know your honest opinions on this. Because that's where we'll start to dot our I's, cross our T's, and of course, when we do our resolution approving the sketch plan, you know, Mark did a very good job of numbering our concerns and saying this is, you know, our approval of the overall outline conditioned upon
And
an
this-
ag easement
This easement,
acceptable to
this
the board.
easement is 100% what Jackie Fenlon, who now is the operating head of this Community Preservation Fund, says that when they do one of those in the town, this is the wording.
I know Jackie well. I go back
For-
years with Jackie.
4 out of 5 plus a referendum. That is what the CPF, to get involved with anything, insists to extinguish so-called agricultural easement. Now, the other terms are you going to grow left-handed llamas and bears and, horses? There are things that are permitted for stuff that's set aside for, quote, agricultural purposes. It's elastic.
well, it sounds like you have some knowledge that you should take a serious look at this
Oh,
and
I'm-
educate us if you feel the need.
I read
Llamas
two or three
and
times.
anything else.
So it's not just
I have an
llamas
opinion.
too, you know,
I have an
one thing
opinion.
that's happened in the city before is somebody sets up like a vineyard, and then all of a sudden they build a wedding venue.
Oh, yeah.
So we wanna be
that's a-
really
Yeah,
careful.
I know, but I,
This summer houses is on
yeah.
record.
Well,
I'd like to make a motion that we close. I'm sorry.
I have one question is, how are we gonna get clarification about the access to the pond and what that access currently means?
So, John, I think you have a copy of the easement language that was filed in the 1960s. So maybe as part of your preparation in addressing the a written decision, you could see if that language is enough to satisfy the board's concerns, and if not, that's something that the board can address as part of their decision if there's conditions that they feel would be sufficient to address the concerns. Does that sound fair?
Excellent, excellent. I can definitely do a deep dive on that. That also should be, that's in the Dropbox, correct?
I believe it is. Yes.
It's kind of a dingy gray document, but if you, I encourage you all to read every document that goes into the Dropbox. But it's from 66 or 7, and it deals with a subdivision directly across, that would be to the west, on fronting on this pond.
That was the Glenn Halsey subdivision.
Great. Any other for the record?
All right, you know where to
comments?
find me if you all have any questions, and of course,
Likewise.
Eileen Powers is also here.
Motion, I'd like to make a motion that we adjourn the meeting. Close.
Seconded.
All in favor?
Aye.
Aye.